Great, thanks for your help. So I'll just send you a link after this. So it looks like we have, excuse me everybody, looks like we just have a few more sandwiches there if you guys want to grab something before we get started. I'm going to introduce our speaker and kind of kick things off here. So my name is Josh Wyndham. I am the president of UNC's Federalist Society. We're kind of retooling our chapter this semester, so if you want to join our listserv, it's my email address, and I'll put you on there. Dr. Ghate is a senior fellow and chief content officer at the Ayn Rand Institute. He's the Institute's resident expert on objectivism and serves as the senior trainer and editor. He's taught philosophy for 10 years at the Institute's Objectivist and Academic Center. So give a round of applause for Dr. Ghate, please.
Thank you, Josh, and thank you for the invitation to the Federalist Society. It's a pleasure to be here. As Josh said in the introduction, so I'm not a lawyer. I'm a philosopher, and that's my background and my expertise. But I obviously think that anyone should be concerned about the law because it affects us all, and that the law in its foundations, and particularly when you get to constitutional law, is very philosophical. So part of what I'm trying to do is to bring a philosophical perspective on some of the issues about religious freedom and framed around the Hobby Lobby decision. And I think that decision gained sort of pretty high prominence in our culture and in discussions on the news and so on for two reasons, and I'm going to focus only on one. So one of the reasons was it had to do with Obamacare. And that's a hot political topic. There's still, even though it's been enacted, there's still a lot of disagreement about it. Republicans threaten in various ways that they're going to repeal it, and so on. So the fact that the decision could affect and maybe pull back or rescind some of the law, I think that's part of why it gained real attention. But the second reason, and that's what I want to focus on, is the issue of religious freedom. And it seemed like you're caught in a contradiction or a paradox. And one way to put it is that the free exercise clause of the First Amendment and the no establishment clause of the First Amendment seem to be in conflict. So the issue was that Hobby Lobby and some other companies, but I'm just going to focus, just call it as everybody does, Hobby Lobby, is objecting to the contraception mandate instituted by the Affordable Care Act, Obamacare, and that this is interfering with our free exercise of religion. That we have strong, sincere religious beliefs that certain kinds of contraception are wrong, and they were objecting to 4 of 12 that have to be covered, and it's being mandated. And if we have to do this, it goes against our conscience, it goes against our religious beliefs, and you're interfering in a significant way with our ability to freely exercise our religion. But if you turn around and give them an exemption and say, no, you're not subject to this aspect of the law, it seems like you're granting somebody, or in this case a corporation, privileges because they're religious. And that's going to, well, isn't that what the Establishment Clause, you're not supposed to elevate a particular religion or religion as such as you gain special prominence and special privilege, and the government's going to do you favors, in effect, and try to prop you up. And there was the idea, well, that's what you would be doing if you're giving them exemptions that other people can't get. So you're elevating religion, and that's the Establishment Clause is supposed to be, no, that's not the government's business to try to promote or elevate. So it seems like there was a clash between them. And another way you can put it, and I think this is an issue that everybody should be concerned with, the whole idea of exemptions for a law. This is a law applied to everybody, except for the people whom we're going to exempt from the law. And do you really have rule of law if you can exempt people from laws? And I think that issue disturbed people too, that yeah, you can have laws that supposedly apply to everybody, except we're going to carve out exemptions for people. And when you get to a point where it seems like the First Amendment, the free exercise and the Establishment Clause are in conflict with one another, that you have to interfere with freedom in some way or another. You have a sort of paradox or contradiction. I think what you have to do in that kind of case is rethink your premise, rethink how you got here. And I think the two things that really need to be rethought is what the First Amendment means and what the Free Exercise Clause and the Establishment Clause mean. Why, I think on a proper reading of the First Amendment, there's no special thing called religious freedom. That is a freedom enjoyed by religious people that's not enjoyed by other people. I think, and then you can put it a little differently, that what the First Amendment is about, to use Jefferson's metaphor, is a separation of church and state. And to get what that means and what it meant, because I think it's completely misunderstood now. And they dealt with these kinds of issues. And before it's enacted into law, it's philosophers talking about this kind of issue. For instance, Locke, who's one of the central figures on the issue of separating church and state, has discussions of, do you give exemptions and things like that. And there's a worked out view that I think is forgotten. So I'm going to talk a little bit about that towards the end of my remarks. So it's the First Amendment, and then more widely, the way in which I think the initial conception of government in the American founding, so if you look at the Declaration and the purpose of the Constitution, versus how they're thought of now, that they've been radically turned on their head. And if you turn them on your head, you get into these conflicts that seem that you can't be solved. That in some way, either you're going to say to Hobby Lobby, yeah, no, we are interfering with your free exercise of religion and we have to. Or else you say, no, we give special exemptions to the religious, but we can't give it to everybody and so on. So you're elevating, it's everybody's equal before the law except they're not. And that you're in that kind of conflict. And I think in the end, it's because the way in which we think both about you can put it very simply as the purpose of government. So those are the two issues that I think really need to be rethought. And I'm going to come to those, but I want to now put them into the context of what was going on in regard to the law, and in the way that in the Hobby Lobby decision, the court, and in the majority decision, the way they talk about what was going on. So that the decision focuses on the Religious Freedom Restoration Act of 1993. But to get just a little bit and of the court's view of why that was enacted. So earlier decisions of the court had allowed exemptions in a certain kind of way. And two they really highlight is, I always mix up the two. Sherbert v. Warner, which is 1963, and Wisconsin v. Yoder, which is 72. And the first one, so the Werner one, it was someone refused to work on the Sabbath for religious reasons, was fired, wanted to collect unemployment benefits, and the state objected that, no, I mean, this person's not ready to take jobs the person could do because they refused to work on the Sabbath. And a requirement of collecting unemployment benefits is that you take jobs if they're available. So they didn't want to pay benefits. And the court said, no, you have to allow this kind of religious accommodation. You have to give them an exemption. Somebody else, if you say you refuse to work because you love the opera and all the performances on Saturdays and you don't want to give that up, you couldn't get, I mean, that wouldn't fly. So they're getting an exemption that other people, and you might really, really love the opera. It can be a really, really deep value to you, and yet, no, you don't get that. So it's the idea that you have a religious reason for it. That gives you special privileges that if your reason isn't religious, it doesn't give you. You can't get it. So there was that in the Wisconsin v. Yoder. It was about the compulsory education. And so it was the Amish, or a group of Amish, who were objecting to having to send their children to school after the age of 14, and said, no, we want them educated at home and so on. And the court granted them, yeah, you can do that for religious reasons. And again, you can't just for any reason say, no, I'm exempt from this law that supposedly applies to everybody, but you can for religious reasons. So it was, the courts were granting these kinds of exemptions. And then in the case of 1990 of Oregon v. Smith, that's the peyote case of the Native American Indians. This substance has been outlawed along with others, and it's a criminal offense to take this substance, but it's part of their religious rituals. So can they get a religious exemption from a law that applies to everybody? And the court reversed in a certain way and said, no, you can't get a religious exemption. For laws that are neutral, so that the goal of the law is not to penalize some religion, so that they're neutral and of general applicability, that they apply to everybody. So a criminal statute, and you can't consume this drug. And it wasn't, so if the criminal statute had been, you can't consume peyote, and that's it, then it might be, well, this is intended to interfere with a particular religious exercise and nobody else. But that's not what the statute was. It was more generally about controlled substance. So it's neutral. It's not aimed at interfering with the free exercise of religion. It applies to everybody. You can't grant religious exemptions to that. And in light of that decision, then Congress passed the Religious Freedom Restoration Act and said, in effect, they're saying, no, we want to be able to still carve out exemptions. And so in the Hobby Lobby case then, what they're focused on is not as much the precedents of the court as, well, now there's the Religious Freedom Restoration Act. And under that act, there's a balancing of, as they put it, of government interests and of the First Amendment. And you need to balance these, and there's a balancing test. And the government has to show it has a compelling interest in passing this law, so in this case, the Affordable Care Act and its various provisions. And if it has a compelling interest, it has to show that that is interfering with somebody's, so in this case with Hobby Lobby's ability to act on their religious beliefs. If it can show it has that interest, then it has to show that it's interfering in the least drastic way. I mean, it's put more technically than that, but there's not something it could do that would be less of an interference. And the court said that, okay, so this imposes a substantial burden on the free exercise of religion for Hobby Lobby, that they would be subject to enormous economic fines and penalties if they didn't go along with the Affordable Care Act. So there's a substantial interference with their free exercise of religion. The court assumed that the government has a compelling interest here, but that it's not the least restrictive way of interfering because, and this is part of when you, if you know about the Affordable Care Act, it's granted a lot of exemptions to a lot of people, including on religious grounds, in the very formulation of it. And the court says, well, you've given you've made these kinds of accommodations and exemptions already in the law. You could have done it and should do it in regard to Hobby Lobbies. So they're exempt from it. And part of what I think is really interesting in thinking about the dynamics of it is that the court regards the Religious Freedom Restoration Act as giving greater protection to the exercise of religion than the First Amendment. And let me read the two and ask yourself, if you put aside court decisions on, which is the stronger of these? That is, which gives more protection to the exercise of religion? So this is the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble and to petition the government for redress of grievances. So Congress shall make no law. This is the Religious Freedom Restoration Act. It prohibits the government, quote, from substantially burdening or person's exercise of religion, even if the burden results from a rule of general applicability, close quote, unless the government, quote, demonstrates that application of the burden to the person is in the furtherance of a compelling government interest, and two, is the least restrictive means of furthering that compelling government interest. So the first tells you it can't make any law that interferes with the free exercise. And the other tells you it can do so under these conditions. Now, which is stronger of those two? And I think it's obviously the First Amendment is stronger. And we're now in a position where it's taken as, no, the First Amendment doesn't give that much protection. And that's what the Smith case is. No, I mean, the government can trample on free exercise. But the Religious Freedom Restoration Act gives you something stronger. And that, I mean, I find both from a philosophical, but from just a common sense perspective, that's crazy. And that the court can discuss it like that, I think is a real indication that something has gone wrong. And that's now what I want to talk about a little bit. What does the First Amendment mean? It's not primarily about religion. Or let's put it differently, it's certainly not only about religion. What I just quoted, it's about free exercise, establishment, free speech, freedom of the press, freedom to assemble. It's wrong to couch it as it's about religious freedom, as though religious people had some kind of freedom that other people don't. I would put it, and in philosophical terms, this is how it would have been put, and this is, if you read Locke, for instance, it's about intellectual freedom. That includes a person if he has a religious viewpoint. But it's much broader than that. And freedom of speech is the freedom to put forth any viewpoint or any idea, religious, non-religious, atheistic, anti-religious. And same with assembly. It's not only assembly on religious grounds or something. So the First Amendment has a much broader focus. It's on preserving intellectual freedom. So, and now if you take, now the clauses focused on the religious aspect, the free exercise clause and the establishment clause. What do these clauses mean? And why are they thought to be compatible, that they don't lead to some kind of conflict or clash? Well, the free exercise clause means you can hold any religious viewpoint, profess it, set up a church in regard to it. Yeah, that's part of the assembly. You can do that, and the government doesn't take awareness of it. It's not interested in that issue, and it does not penalize anybody. You've got the wrong religious viewpoint, or you don't have a religious viewpoint and you should. And therefore you're going to be subject to government penalties, fines, what have you. I mean, it can be to the point of imprisonment and even death when you think of the religious wars in Europe that they're coming out of. And that they're, one of the major reasons they're trying to separate church and state is that we're not going to go through that again. So it is, you can hold any viewpoint and the government doesn't penalize it. Nor, and this is the establishment side, nor does the government have any focus on promoting a viewpoint. And you can put it as a religious viewpoint, but if you read Jefferson on this, and the First Amendment is modeled on the Religious Statute of Freedom of Virginia, which is Jefferson's the author of, when you read that and his discussion of it, it is your rights don't depend on your religious views any more than they depend on your views about physics or geometry. And it's not, the government can't go, I mean, there's all kinds of disputes in physics, say, to take one of the Enlightenment ones, of is Descartes' vortexes right, or is Newton's view right? Take a more modern one, there was a whole controversy about, is the concept of ether, does this make sense? And should we look at physics like this? And it's not the government's purview to say, yeah, well, the ether view's right, the other ones are wrong, we're going to give special favors, special funding, special rewards. That is, we're going to help establish that viewpoint. So the Establishment Clause is, it's not the government's business to establish a viewpoint, religious or otherwise. The free exercise is, it's not the government's function to penalize viewpoints, religious or otherwise. And the view was, that's what intellectual freedom looks like. The government is not penalizing ideas and it's not promoting ideas. Now, does that give you exemptions from laws? And the view was, no, it definitely does not give you any exemption from any legitimate law. The purpose of a law is to secure the rights of an individual. And that has to happen regardless of individuals' viewpoints. So, and these are kinds of examples that come up explicitly in the discussion, because what they're trying to do is separate church and state. So they're trying to figure out, so does this mean if I commit murder in the name of my religion, I'm exempt from penalties for murder? And isn't that, or otherwise you're interfering with my free exercise of religion because it's telling me to kill the infidels or kill blasphemers? And the view was, no, if something is actually a crime, such as murder, which means, it's the complete violation of a person's right, his right to life is gone. That is against the law, and it doesn't matter what your reasons for it are. You don't have a right to take that kind of action. On religious grounds, on non-religious grounds, on anti-religious grounds. If somebody started killing religious people, it's where you can't. So there's no exemptions. But there's also not the kind of interference with the whole realm of ideas, because it's not the government's business to try to establish some, penalize others, so on. So they thought that, and I think they're right, that the principle of separation of church and state was a clear principle. And it gave you clear guidance on these are laws, and there's no exemptions to them, religious or otherwise. And this is a whole field in which the government doesn't enter. And that's what separation of church and state looked like. And that's what they meant by it. And so they didn't think there's any kind of tension between the Establishment Clause and the Free Exercise Clause, which is why they're in the same First Amendment. There's no conflict between them in the original conception. So the question then is, why are we at a point where they're thought to be there's a tension between them, and even indeed there's a conflict and a contradiction between them? And it's because I think the reason is we've radically turned on its head both the Declaration of Independence and particularly the Constitution and its meaning. So to really get what separation of church and state meant, and I think what the First Amendment is trying to do, you have to get that they're taking seriously the whole viewpoint of the Declaration of Independence, which is that individuals have rights and that government is instituted to secure these rights, which is the language of the Declaration. Government is instituted to secure these rights. That's its function, and that's it. It's there to secure the rights of the individual. Part of what that means is that a government doesn't have interests of its own. So I read from the Religious Freedom Restoration Act, a government compelling interest, but that's all over when you read the Supreme Court decisions. We have to, and what we're trying to balance is the government's compelling interest with the rights of the individual. There's no such balancing in the original conception of America because there's no such thing as government interest, let alone compelling government interest. all that the government does is secure the rights of the individual. So you can think of it like this, and this is the kind of, philosophically, the kind of analogies they would give, that government officials are your delegates. And you can think of that, or your representatives. I mean, the language that's still used, but I don't think it's understood what that really means and how fundamentally different a conception of government it is. They're your delegates, they're your representatives. It's like if I hire a lawyer to represent, I'm buying a home, to represent me in that transaction. In that transaction, that lawyer or real estate agent that I'm hiring doesn't have any interests of their own. They're there to represent and secure my interests. And that's it. But once you get this whole conception that a government has interests of its own, it's like you have two people with clashing interests. The government has its interest, and then they'll talk about it has interest in giving health care to everybody, looking after people in retirement. The Social Security. It has these interests that it's pursuing, and it conflicts with people's interests and rights. And what do? And sometimes the government's interests outweigh the rights of the individual, and sometimes the rights of the individual put brakes on the government pursuing its interests. And that, when they're talking about balancing, that's what they're talking about. And the original conception of government is there's no such balancing. So the kinds of conflicts that we get into now with the First Amendment and the free exercise and the Establishment Clause, they didn't think those could arise because the whole idea of government pursuing ends of its own it's not on the table when you're talking about the original conception of government. And then it is even more, like I've put it as it's sort of two equals. There's a government pursuing its interests and individuals with their interests and rights, and it's like two, but it's not really two equal. It's the government is by far has the upper hand in the way that it is thought of now. And I think that this is the other way in which we've lost what the real I think we've lost what the real meaning of the First Amendment is and what it means to say it separates church and state. And more generally, or more widely, what we've lost is the whole conception of government and the idea of it having interests of its own, ends and goals and values of its own, is part of getting that we now have a radically different conception of government than existed when the Constitution was written and when the Bill of Rights was written. And one way to put that, a different way to put that we have a very different conception of government now is that I think a proper reading of the Constitution is that what it is doing is specifying the powers that the government or the federal government has. So it in effect is saying, if something is not explicitly permitted to you, it's forbidden. If it's not explicitly permitted to you in the Constitution, it's forbidden. That is, the government doesn't have that power. And now it's much more that it's flipped. If something is not explicitly prohibited to the government, if something is not explicitly forbidden to the government, it's permitted. So the bill, and this is what people worried about in regard to the Bill of Rights, that it would be taken as exhaustive, that these are only the rights that people have, and if it's not specified in the Bill of Rights, then you don't really have that right. They worried about that if you try to specify every single right a person has, you're going to lose because you can't do it. You can do it in terms of principles in the way the Declaration of Independence does. A right to life, liberty, and the pursuit of happiness. Property is not in there, though it's often in the formulations. You can specify it at a level, but you can't specify in every detail what every right a person, and you don't need to, because it's not as though government can do anything unless there's some explicit thing that forbids it. Because the review was the reverse. It can only do what is explicitly permitted to it. And so the way the First Amendment then, and this is why now it is thought of that there's some special freedom, religious freedom. because the First Amendment makes reference to religion, to free exercise and the establishment. I think a proper reading is it's much wider than that. It's about intellectual freedom. But it doesn't specify every aspect of intellectual freedom, but it specifies some, such as freedom of speech, which is why the US still has better protection for free speech than most other countries. If you take, say, France, if you followed it all in the aftermath of the Charlie Hebdo massacre, of what the laws in France are in regard to free speech. They're awful, I think. We have more protection on it because it's explicitly mentioned in the First Amendment, and it's the same with it's explicitly mentioned. So I guess we can't interfere with that aspect of intellectual freedom in the way that we interfere with all kinds of other aspects, willy-nilly. And that's why, to go back to the idea that someone objecting, I don't want to work on Saturdays because there's something really valuable I have to do on Saturdays. And I gave the example of attending the opera. That doesn't count. But it counts, at least it has some weight, if my reason for it is religious. Some book 2,000 years ago says I can't do this. That's a good reason. That I value opera is not a good reason. And the only reason that distinction is made is because the First Amendment explicitly talks about religion, doesn't talk about the opera. And that's reading the Constitution now. If there's not something that explicitly seems to forbid it, we can do it. And the government has the power, and there's no constitutional issue. And that flips it completely on its head, of what the meaning of the Constitution, and it leads to constant clashes. Because it is the government pursuing its own interest, and it can do whatever it wants, except when there seems to be something that says, no, you can't do this. And that's why it now only focuses on religious issues. Because and there's a real reason that aspect of intellectual freedom was being singled out, if you think of the history of Europe and the incredibly protracted religious wars in Europe. There's a reason they're singling this out, and they're talk about separation of church and state, and that is a crucial part of preserving intellectual freedom. But it's not all there is. But now it is all there is, and that's why there now seems to be, there's a special thing called religious freedom, which I do not think is the right way of reading the First Amendment, as I've been arguing, nor the right way of looking more widely at the intellectual and philosophical history of what's leading to the First Amendment. It's not as though this is what counts and not other things. And again, for an American source on this, read Jefferson, where it is, it's not that there's some special privilege being granted to the religious that other people don't get. That is now how everything is looked at. And I think that's the context in which you have to look at the Hobby Lobby decision. And in that context, there's a real way, I think, that you can't get a right decision. If they had said, now I lean much more to not give exemptions to laws. And it should be, Hobby Lobby, you're subject to this as everyone, because I think there's all kinds of problems with giving exemptions. But it is true that it is a violation of their free exercise of religion. If you make them do something that they think goes completely against our religious beliefs, you are interfering with their free exercise. But if you grant them exemptions, then you're saying, well, the law doesn't really apply to you. And that doesn't make sense either. So that you're in a no-win situation. But that's not how they thought when they're separating church and state, that it will put you in no-win situations. But if you have a radically different view of government and a radically different view of the Constitution, then you are put into no-win situations. Okay, so let me stop there and open it up for questions and discussion. Yes?
You mentioned kind of the dichotomy between the people's interests in securing their rights and the government, their interests. Is the government's interest not reflected by the people?
Well, what do you mean by reflected by the people?
Well, being that, government officials
Well, they reflect some in some kind of ways, but that's part. So part of the whole conception of rights is that they don't come from majority decisions, and you have rights even if the majority is not respecting them. Now, it might be your rights aren't then secure, but the whole function of government is to try to secure them. So it's not, there's not, even though it's true that the government is elected and in that sense represents in a certain sense the will of the people, that will can be wrong, and it can be that we want to violate rights all the time, and that's considered as, well, but that's an interest of the government. So what I'm getting at is that it's pursuing what it means to say government has interest is it's pursuing some kind of goals, values, and ends other than securing the rights of the individual. That's really what it means, and that's why they use the term. Because it's, again, if you take the analogy that I gave of a real estate agent, I mean, you could say, but you wouldn't say it, but you could say, well, her interest is achieving my interest, but then it's not. That's her function, is just to pursue my interest. And when she starts pursuing her own interest in the transaction, in the sense of, I'm not going to try to negotiate a lower price because I'll get a higher commission if the price is higher, because it's a percentage of the sale price. She's not looking after my interests if she's representing me as a buyer, and that's a violation of, and it's the same, I think, I view government, and I think the founding fathers viewed it, is that the government starts pursuing goals and ends and so on, other than just protecting or securing my rights, it's doing something wrong. But it's no longer thought of like that at all. Yeah.
You talked a little bit about what the people's interests are. I'm sure this is a question on a lot of people's minds, just based on the content of the lecture and the subject material. Can we have an interest in healthcare in the sense that it's a right that ought to be protected?
Well, yes and no. I don't think there's such a thing as a right to health care. That means a right to be provided with health care by the government. And the original conception of rights and the philosophical conception of which is what the Declaration is focused on, life, liberty, the pursuit of happiness, they are about action. They are about the pursuit of goals, and that somebody can't interfere with those. So what your right to health care is the right to engage in production and trade in the end of it. I should be free to pursue health care on a market that is buy insurance, buy services I want, contract with doctors, not see a nurse instead of a doctor, even if licensing requirements say that she can't do it, and if I think the person's he or she as a nurse is competent to do it, I should be able to contract with. That is what rights, I think a proper, if one's thinking of the rights as conceived of and formulated in the Declaration of Independence. The concept has been inflated from going to your pursuing goals and ends to the realization. So the pursuit of happiness is not a guarantee that you're going to reach happiness, and it's certainly not that the government has an obligation to do things to make you happy. It's just to leave you free to pursue it, and I think all those, they have to be, healthcare is, I have to be free to pursue it. But not that the government's going to provide me with it any more than it's going to provide me with happiness. But now when people talk about a right to health care, it doesn't mean the right to pursue my health and medical services and so on. It means I've got a right to the outcome. And then the question always is, well, who provides it? And it's other people. And then it's, well, what happened to their rights?
You kind of talk about intellectual sort of beliefs versus religious beliefs. Isn't there some fundamental difference between those two things, at least in the eyes of most people, and including the founders?
In what way do you think there's a difference?
So my belief and love for the opera, as you used, would be different than somebody's belief and love in a God?
Well, so they're different in subject matter. So, and this is part of Jefferson's point. It doesn't depend on your religious beliefs any more than your beliefs in physics or your beliefs in geometry. So they differ in subject matter. But are you trying to get at there's some other difference than that?
Yeah, because they're treated differently throughout sort of history. Everybody gives more to religious beliefs than just merely intellectual beliefs. So,
I don't think that's true in history. But so there, if this is the element you're trying to get at, that religion and morality often are thought of as going together. Though I think in this period that is being split apart, and you don't need to be religious to be moral. But so if you're taking it's moral convictions, it's fundamental convictions about how I should live my life. If that's what makes it, and it's part of what in some of the court's decisions they do broaden it from religious to philosophical / moral. It's deep convictions of a person. But I think you can have a deep love of art that is as deep and as profound as a person's religious sentiments.
So then what distinguishes those two things, or is there any?
I don't think there is. There is in the context of separation of church and state, but that is a degrading of religious view. So I gave part of what I think is going on in regard to separation of church and state, but there's more than that. There's the issue, so I put it in terms of the religious persecutions and so on that going on, and that was a major element of religious warfare in Europe. But there's another aspect, and that's more on the establishment side that I didn't talk about as much, which is that religion should not wield political power. And that means that there's a way in which religious views are being downgraded. And I think they have real reasons for why they're down. It is, you can't put political power in the hands of faith. It can't be directed by somebody saying, I don't have reasons or arguments for this. I believe it on faith. You can't allow a government to function like that. And think of it again a simple kind of example. You can't have a valid criminal trial where the judge or the jury can go put into elements of their judgment, elements of faith. I'm dismissing this person's testimony or diminishing it because they're a woman. And my faith teaches that testimony is not as good as the testimony of a man. You can't get a just trial if you allow that kind of thing in. And there's a broader viewpoint of that. And that's why there's no religious test for oaths of office and that kind of thing. You can't make political power wielded by faith. It has to be wielded by reason, grounded in arguments, and that's part, I think, of the viewpoint going. So there is that kind of distinction to be made, but it's not relevant in terms of a rights of the individual, in the sense that you can hold those ideas, you can hold faith-based ideas, and the government's not going to try to say, no, you can't do this. But you can't run government like that. So, that's some at least on the question, but it seems you're not quite what you're asking. We can talk after the talk. Anybody else? Yeah.
So you just a question before about healthcare not being right, and the government not really being there to give you something like healthcare. How far do you extend that principle? And what do you, for instance, with public roads or public education? Doesn't sometimes, though things may not be a right, because we do espouse this pursuit of happiness, we do ask our government to help facilitate us towards goals. Even though, say I might be a transcendentalist and I have a deep love of nature and I don't want to see a public road go up or that might lead from one town to another and facilitate other people's pursuit of commerce or pursuit of business and like transactions. So how do you do it?
So there's two different things there, though they will often be lumped together the education, roads, and things like that, as they're all public goods. But I would make a distinction. So I'll come back to the education issue. The public roads and that kind of thing, there's a viewpoint which I think is wrong. That the reason you need government to do these things is they don't happen unless everybody gets together and we build a road or we build railroads. But when you look at the actual history of these kinds of things, including the railroads, they're built by private interest when they see that it's valuable to build. So you don't have these roads to nowhere or bridges to nowhere. They're built when they're economically valuable to build them. And it's sometimes it's not obvious, and it takes private company, like people think they're crazy, it's hard for them to get investors and so on. But that's part of what should happen in a real economy. You have to convince people that this is really worthwhile to do, it will be profitable, people will use these roads, people will use the railroad, and that's what entrepreneurs do. If you look in England with the use of canals, if you look in the there's many kinds of cases where people will say it's impossible that markets will do this. And then you go and find, well, no, there are all kinds of places where markets do this. Money is another thing that has it. Well, you need government to run money and control the money supply. There have been many cases in history where the money supply is not run by the government, and people create money, and they create banks, and they create lending, so all private currencies and so on, because it's needed. It's really economically valuable to have it. So I don't think there actually are goods like that. But that is an argument that there are goods that are obviously valuable, won't be created by a market, so have to be created by government. But I don't actually think there are things like that. But that public education, I'll let you follow up, but public education is much more significant than that. I think it's I think obviously the biggest flaw in the founding is the whole attitude towards slavery. It's an enormous contradiction to have slavery in the Declaration of Independence, and it's part of what came to a head decades after that. But the attitude towards public education, and it's a mixed attitude, but many people are on the side, yes, you need government to have public education, you need an informed citizenry to have government, to have a well-functioning government, and so government has to provide education. I think that is all wrong. And it goes to the issue of intellectual freedom, and that's why I'm not putting them all just into the issue of public goods. To allow government to control the educational system is to allow it to control the realm of ideas. I mean, it really is to do that. And I know some people, and I think this is right, if a foreign government had taken over the school in the way that we have public schools now, and even much of secondary education, it's not a government monopoly, but the government has vast control over what gets researched, what gets funded. If a foreign government had done this, people would rebel and say this is an act of war. They're trying to take over our country. But if our own government does it, then I guess it's okay. And I don't think it is. It is what real intellectual freedom is you would have to be, so when they talk about a marketplace of ideas, you as a professor, you as a researcher, a medical researcher, you're interested in ancient history, so you would need to compete on a market and get people to think, yeah, that is worth supporting, that it's a university worth attending, it's research worth, and you would have to really show it's valuable. And it's not that it is when we've got the power of government, which in the end means the power of force, to put penalties on people, and then of the people they've penalized, take some of their resources and give it to other people, which is to reward other people. That kind of power in the realm of ideas, I think, is really, really detrimental and dangerous. So I'm really on the side for public education, that the government should not be involved in. And it is for the issue. I view it exactly in the same kind of ways that you want an informed citizenry, but the only way to have an informed citizenry is that they're free, and not that they're controlled. It's all controlled or semi-controlled by the government, I think. And when you look at what U.S. education throughout the 20th century has been and the ways in which it's declined, I think there's a cause and effect in regard to it being more and more controlled by government. But that's obviously a controversial position, but I think it's a really, really important issue.
Great. I think that's it. Thank you guys for coming today. If you want to join our listserv, please email me. My email address is up on the board.
So,
So I guess what I was going to I know a lot of the issues in this realm is definitely whether it's whether it's
other than beliefs about the supernatural, the food all get eaten. So,
Yeah, it was really quick. I only had like 40 sandwiches, and I didn't think more. I felt like 20 people showed up.
I was gonna say.
yeah, I mean,
Yeah, I got really lucky. Thanks for coming, man. I really appreciate it.
it was interesting. It was a great
Yeah, good. Hey, thanks for coming.
No, Kevin drove.
I tried to believe like really.
We just
Oh, I know that.
underestimated. How are you?
Thanks for coming.
How are you?
How are you?
Yeah.
Awesome. Cool. Good. I'm glad you guys liked it. I thought it like create that box. I really appreciate that. You guys working on a lot.
I like ramp set. Yeah, it is. We drove by, we're already running late.
Well, sorry about that. You tried to get like super. Yeah. Okay. Cool. Awesome. I get more quickly. I thought like 20 people would show up, so I got really lucky with the turnout. So thank you guys for coming out. Yeah, thank you. I got this. How's your day? Oh yeah.
Pretty much.
I haven't seen Derek in a while.
Well, we'll be both.
Oh really? Is that crazy busy? Did you find out about I see it just now.
Yes, I got, yeah.
That's fine.
I talked to my friend, she was
Yes, I am.
basically last minute. It's
I asked
I
for
did
guys
it
to
in the
forget, and they were like,
yeah, if she sits at the table.
crazy sold out.
Emma
Yeah.
wants to get in touch with Kevin for some stuff.
Okay.
It's good to be here. I was
His
in the garden.
girlfriend.
I have a question.
Yeah.
Sure shot. I'm trying to fill out AFP chapters on college campuses, something we've never done before. I would like to know sometime.
Yeah, sure. Let's sit outside real quick so we don't.
Yeah, is there a class in here?
There is, and I'm sorry we're intruding on that. Hey guys, can we just kind of move on out of here so we can let this professor have his classroom? Thanks for your help. Morning. Do I need to do anything or?
I'll send you a link probably in a couple hours.
Thanks for coming.
Thanks for calling.
Sure. Yeah. What's your name?
My name is Janet Wilbur.
Great. Awesome.
I think I'm a participant.
Oh, really? Okay.
Anyway, the Federalist Society,
Yeah.
can you tell me in a sentence or two what they're about?
Sure. I mean, they are they're conservative in libertarian-leaning national organization, and they have clubs and philosophers, like speakers from that general area. So there are conservatives, there are libertarians, there are there's like Onkar Ghate, kind of all over the right side of the spectrum. Okay. Okay. I'm in my second year of 3. Just got to get Great to meet you. Yeah.
Nice to meet you
Good thing.
too, John.
Sure.
How's the technology been working
Oh yeah. Lots of. Well, sure thing. What's your name?
Yeah, that one's from my.
Oh, great. Well, good to meet you. Thanks for coming.
But yeah, I'm not in that room anymore. I see whoever it is.
on? You know what? I don't think anybody's heard that most of it.
Yeah, you have a good one.
We have different seats every time we come in here. It's just I just remember how I was being like that works. I know. To me, I don't know how you keep it straight. It's like the same room, January 16th. I would get it all mixed up, like all the classes. I used to be the same thing. Always in
Remember we had some silver in
Even I took allergy medicine the other day. I didn't do anything for me. Every single class has. Yeah.
I saw you laboring.
I was. No, it